Mr. Randolph, in cause number 24, DCCR 1923, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon, and that's from June 15th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Randolph's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. Will give me more information about you, your case, and then we will come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Good morning. Are you Albernica Conning? And Ms. Conning, you were previously in court and entered a plea of guilty to aggravated assault with a deadly weapon, second-degree felony. I've received the copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections?
Not from the defense.
No, Your Honor.
All right, Ms. Conning, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You are ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete it. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Part of your probation, the conditions, is that you have absolutely no contact, obviously, with Anaya Johnson, Nikki Lawrence, Lyric Lawrence, and Deanna Darjean. Do you understand? That doesn't mean just in person. That means any contact or communication. No sending messages through DMs or any social media, emails. No telling other people to tell them things. Stay away from them. Steer clear so that you don't end up back here in trouble and going to prison over anything like this. Do you understand? Also, you are not to be anywhere near the Regent Street apartment complex in Beaumont. You understand that as well, right? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I will be signing dismissals in cause numbers 24 DCCR 1574, 1576, and 1577 as part of this agreement. If you just need to have a seat here in the courtroom, and then probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Good morning. Are you Christian Boutte? And give me just a second. All right, and will your client waive the formal reading of the indictment in each case?
It will, Your Honor.
Did we, did I do something before on these? Somehow I have a prior version saved. So maybe I accidentally did it for. Sorry, give me just a second. I don't know why I would have done that. April 14th. On
the indictment?
yeah, 2078 on the indictment. So, all right.
I have to go back and look at my.
Well, do y'all want to delete one, or can you? It doesn't matter, because I'm not making any notations on it. He's pleading to the indictment, correct?
Yes.
Nothing different. All right, so, Mr. Boutte, in cause number 24, DCCR 2078, you're charged with a third-degree felony offense of forgery of a financial instrument from August 21st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? And then in cause number 24, DCCR 2079, you're also, in that case, you're charged with the state jail felony offense of forgery of a financial instrument from May 7th of 2024. And how do you plead to that charge? Speak up, please.
Guilty.
And are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? In each of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases, in the third-degree felony, which is 2078, you've reached an agreement for a 7-year deferred probation. There would not be a fine. There would be restitution to be determined between now and when we come back for sentencing. Is that your understanding? And in the state jail felony case, the agreement's for a 5-year deferred probation. Same thing, no fine, and then any restitution would be determined between now and when we come back for sentencing. Is that also your understanding?
Yes, ma'am.
State,
Sorry,
Yeah,
just to let the court know, we do have, and we have discussed some subrogation documents. We just want to double check prior to the PSI that Natchez, what did Natchez have to pay, what did this insurance company have to pay to write it? That way it's going to be pretty substantial, upwards of $60,000.
okay, thank you. All right, state tenors number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Mr. Boutte is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report that will give me more information about you, your cases, and then we'll come back later for sentencing. It'll also give everyone time to figure out that restitution for sure and who it needs to be paid to. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
In this courtroom session, the judge handled several criminal cases involving guilty pleas, probation agreements, and bond violations, reminding every defendant that probation is not a free pass, but a final opportunity to stay out of prison. The first defendant, Randolph, pleaded guilty to being a felon in possession of a firearm. Under a plea agreement, he faced a 10-year prison sentence that would instead be suspended for 10 years of probation if he followed every condition. The judge explained that breaking any rule could send him straight to prison and also warned him about the immigration consequences of a guilty plea before delaying sentencing for a pre-sentence investigation. Another defendant, Alberca Conning, had already pleaded guilty to aggravated assault with a deadly weapon. The judge accepted a deal that placed her on deferred probation for 10 years instead of giving her a felony conviction immediately. He stressed that if she successfully completed probation, the case would be dismissed. However, if she violated any condition, she could be sentenced to anywhere between 2 and 20 years in prison. She was also ordered to have absolutely no contact with several named individuals, avoid a specific apartment complex, and stay away from any form of communication with the victims, including social media and messages through other people. The court then heard the case of Christian Boutin, who admitted to 2 separate forgery charges involving financial instruments. The judge accepted his guilty pleas and explained that sentencing would be delayed until a pre-sentence report and restitution amount were completed. He was warned that the court would carefully review his background before making a final sentencing decision. The hearing ended with a much tougher outcome for another defendant, Garcia, who tested positive for marijuana, methamphetamine, amphetamines, and ecstasy while out on bond. The judge ruled that he had violated his bond conditions, increased his bond to $100,000, and ordered GPS monitoring, continuous drug testing, and strict travel restrictions if he was released again. Throughout the hearing, the judge delivered one clear message: probation and bond are second chances, but ignoring the court's rules can quickly lead to jail or prison.